The non-compete also has to be reasonable in scope, and this is where the time and geographic restrictions come into play. Let's talk about time first. Florida law presumes that certain time periods are reasonable depending on the situation. For most employees, a non-compete lasting 6 months or less is presumed reasonable. If it's between 6 months and 2 years, the employer has to justify why that longer period is necessary to protect their legitimate business interest. And if the non-compete extends beyond 2 years, that's presumed unreasonable unless the employer can present clear and convincing evidence that the longer restriction is necessary. But here's an important exception. If the non-compete involves the sale of a business or is related to substantial business relationships with prospective or existing customers, a restriction of up to 5 years is presumed to be reasonable. So if you're buying or selling a business, the stakes are higher and the law gives more leeway for longer restrictions. Now, the geographic scope works just the same way. The restriction has to be reasonable based on the employer's actual business footprint. If the company only operates in Miami-Dade County, they probably can't enforce a non-compete that prevents you from working anywhere in the entire state of Florida. But if they have customers throughout Florida and you had access to those customer relationships, a statewide restriction might be perfectly reasonable. And for companies that operate nationally or internationally, a broader geographic restriction could be justified. I know this is a lot of information, and if you're finding this helpful, do me a favor and hit that like button.